Okay, this is Chair Douglas, Cannabis Compliance Board. We call this meeting to order. If we can have our formal roll call.
Thank you, Chair. Member Jerry Merritt.
Present.
Member Dennis Nylander.
Present.
Chairman Michael Douglas.
Present.
Great. Deputy Bala, can you please confirm that we have complied with the open meeting law requirements?
Yes, sir, we have.
Great. Chair, with your approval, I'll get started by introducing agenda item number 1. Great. Agenda item number 1 is public comment. Ms. Bonner will now read into the record all public comment received up until the start of the time of the meeting. Any public comment received after the start of the meeting will be read into the record at the second public comment period. Ms. Bonner will end each individual reading at the 3-minute mark. All public comment will be posted online for the public to view immediately following the meeting. Ms. Bonner, you may begin.
For the record, Tiana Bonner, the Public Information Officer for the CCB. The first public comment is from Michael Cristalli. This is in response to the submission by Cheyenne Medical LLC doing business as Thrive and their change of location request. Thrive argues that the approval of the special use permit for the location at 2975 Sammy Davis Jr. Drive, Las Vegas, Nevada 89109 is enough to meet the distance requirement as the use was given to the landowner prior to the change in the regulation on November 23rd, 2019. Thrive was not the licensee on that SUP and failed to apply before the imposition of the new separation requirements. In fact, the original licensee on this SUP wasn't a county marijuana establishment licensee and was not qualified for that location. Thrive fails to acknowledge that MediPharm applied for the change of location on November 21st, 2019, before the change in the separation requirement, thereby giving them grandfathered status to the location. Thereafter, the DOT Marijuana Division approved MediPharm's request. The regulation clearly states that medical and adult use marijuana establishments must not be located within 1,500 feet of non-restricted gaming establishments. A marijuana establishment is the licensee, not the landlord who holds the use. MediPharm, as the licensee, applied for the change of location prior to the new separation requirements, and after careful consideration by the department, MediPharm received approval for the change. The only qualified licensee for that location would be MediPharm LLC doing business as Bloom. All other applicants would be ineligible according to NRS 453D.210, NRS 678B.210, and NRS 678B.250. Please do not hesitate to contact me if you have any questions. We're pleased to provide further information should you require in order to complete your review of this matter. The next public comment is from Jake Long. My name is Jake. I arrived to Nevada in June seeking employment in the cannabis industry here. Given the perceivable amount of preparation time, the CCB's resources are far from adequate. The Acela website used for application is not user-friendly and frankly outdated. The available information on the CCB is jumbled and overly complicated. There's 2 websites, which is erroneous. There's little to no publicity available about your launch in July. You have no social media presence, no new media information available, no live chat available on your website, and you have no mobile-friendly interface options. Isn't there an app for everything these days? Applying for an agent card carries an exuberant financial cost, and applying for multiple classifications means submitting the same information multiple times. You'd think having to pay almost $500 for permission to work in your desired field might at least be a user-friendly process. There's little to no transparency in the presence you seek to impose on Nevada's cannabis industry. In the 8 weeks it took to find the right information and take the proper initial steps, the industry professionals I spoke to were seemingly ignorant of your existence entirely. In my efforts to apply for an agent card, I contacted the CCB and was met with minimal assistance peppered with cold indifference. All but one representative in the CCB corresponded with a sort of deal with it attitude, comparable to the professionalism you'd find from an HMO. Not quite rude, but very indifferent. All the while, my grievances and feedback about your system were ignored completely. There's no mandate on courtesy, but there's enough unpleasantry in the world without the assistance of more gray bureaucrats. I'd like to think a lot more could have been accomplished over the phone, but calling the CCB isn't an option. Overall, I'd rate my experience thus far about 6 out of 10 generously. My question is twofold. Why is there still so much room for improvement? And what, if any, steps are you taking to improve the overall user experience? And in the modern age of telephones, internet, and live chat, why is correspondence with the CCB limited strictly to email and so devoid of basic professional courtesy? Thank you for your time and have a great day. See how easy it was? P.S. I'd be glad to offer my assistance in helping to improve things over there. I could offer your team some training tips on soft skills and probably find you some digital experts to help make things more efficient online. The next public comment is from Russell Ernst. I am one of the managing members of High Sierra Holistics located in Northern Nevada. I'm writing in favor of the settlement between High Sierra Holistics and TRNVP 098. HSH is a locally owned cultivation and production facility in Reno, Nevada. With this proposed settlement, HSH hopes to open a dispensary in Lyon County, Nevada. This will create a new employment opportunities and will provide the county additional tax revenue in a time when tax revenues are desperately needed. The settlement will allow all settling parties to continue to move forward and hopefully open other recreational marijuana dispensaries throughout the state. HSH has been involved with the Nevada cannabis industry since 2016 when it acquired its production and cultivation licenses for medicinal marijuana. Since that time, we've been providing jobs to many Northern Nevada residents, and we look forward to expanding and employing even more local residents at this dispensary. HSH has been diligently working towards a resolution of this litigation, in this case since 2019, and believes this resolution is in the best interest of all parties, including the state of Nevada. High Sierra Holistics respectfully requests the approval of the settlement agreement from the CCB. Thank you for your time and consideration in this matter. The next public comment is from Mitchell Britton on behalf of Cheyenne Medical, LLC, doing business as Thrive for agenda item 6. Cheyenne Medical, doing business as Thrive, respectfully submits this public comment regarding agenda item 6. Thrive welcomes this opportunity to put facts on the record demonstrating to the public and this honorable board why their change of location request is legally justified and should be granted. It's no secret that the granting of new adult use retail store licenses has been mired in lengthy and complicated litigation. That litigation, which the local press has dubbed World War Weed, impacts virtually every aspect of the industry, including this change of location request, which would ordinarily be considered a very routine matter. The opposition to Thrive's change of location request has nothing to do with the merits of their request, but is rather just another attempt by certain parties to the litigation to seek avenues of recovery outside the courtroom, to try and take what they did not earn, and to try to improve the perceived legal position. MediPharm is familiar with the legal requirements for a valid lease and knows that a contract for the sale or use of land must be in writing. MediPharm's claim that it is negotiating in good faith with the landlord is completely without legal merit, as mere negotiations give them no legal right to the use of the property. MediPharm knows that they have no right to the Sammy Davis Jr. Drive property, but MediPharm isn't really here to secure a right to the property. They're simply here to delay/deny Thrive the use of the property or attempt to exert leverage on Thrive in the hopes of a settlement. MediPharm is likely doing this because they fear that allowing Thrive to open their retail store at the Sammy Davis Jr. Drive property will hurt their and certain other plaintiffs' position in the Department of Taxation litigation. The public and the board should also be aware of the relationships involved. Discovery in the DOT litigation has revealed that MediPharm's attorney, Michael Cristalli, is on the board of Qualcan, a marijuana establishment with a vested interest in the outcome of this matter due to its position in the DOT litigation. Mr. Cristalli's firm, Clark Hill, represents several of the plaintiffs in the DOT litigation, plaintiffs who were not a part of the recent settlement. It should be noted that Mr. Cristalli attempted to use this hearing as leverage to further his and his clients' economic interest by offering to settle if Thrive would give up one of its licenses in the city of Las Vegas. If Thrive does not accept, Mr. Cristalli threatened even further litigation. Mr. Cristalli and MediPharm should not be allowed to abuse the process any further to delay the rights of other parties with their spurious claims and strong-arm tactics. Thrive's customers and employees should not have to wait while MediPharm tries to create a cannabis version of Dickens' Bleak House here in Nevada. The facts and the law show that the board is legally justified in approving the requested change of location. As stated in its The next public comment is from Michael Tella. Michael Tella, on behalf of 297-5 Sammy Davis Jr. Drive LLC, respectfully submits this public comment regarding agenda item 6. I'm the manager of 297-5 Sammy Davis Jr. Drive LLC, which owns the property where Cheyenne Medical LLC, doing business as Thrive, has requested to move its retail store license. I am grateful to have this opportunity to put on the record before the public and this honorable board as to why Thrive's request is legally justified and should be granted. It's true that other parties have been in negotiations with me regarding a lease agreement for the Sammy Davis Jr. Drive property, specifically a third party who claimed to be in negotiations to purchase a retail store license from MediPharm LLC, doing business as Bloom. I'm unsure of the third party's affiliation with MediPharm or of their authority to act on their behalf. MediPharm never executed a lease for the Sammy Davis Jr. Drive property and has no legal rights to use the property. Any claim that MediPharm is still in good faith negotiations with the owner of the Sammy Davis Jr. Drive property are false. Thrive has executed a lease for the property and is the only tenant with rights to use the premise. Even if MediPharm were still in negotiations, as the board is likely aware, a contract for real estate must be in writing pursuant to Nevada law, and there's no written contract granting MediPharm rights to use the property in any capacity. MediPharm and their attorneys likely know this and are likely only objecting to Thrive's change of location request to delay and try to force the landlord to comply with their demands. Thrive's change of location request is legally justified. As the board is aware, the Sammy Davis Jr. Drive property already has a special use permit approved by the local authorities. The special use permit was approved almost 2 years prior to the effective date of the legislation that imposed additional distance separation restrictions. The restrictions do not apply retroactively and therefore do not apply to Thrive's change of location request, as the Sammy Davis Jr. Drive property is effectively grandfathered. If the board were to accept MediPharm's position when it has no right to the Sammy Davis Drive property, it would effectively create a public policy to allow cannabis establishments to block the use of properties simply by receiving approval of a change of location, even when such establishment has no contract to utilize the property. Such a policy would effectively be a taking of the property owner's rights, who has obtained land use to permit the property to be used as a cannabis establishment, and would do nothing to serve the public interest. The voters of Nevada voted to approve the opening of new adult-use cannabis retail stores. Now, perhaps more than ever in our history, our state needs these new retail stores and the jobs they will bring. We need commercial properties rented. We need the jobs that tenant improvements will bring. We need the security. The next public comment is from Ardea Canepa Rotoli. The law firm of Maddox, Saker, Bloom, and Canepa represent a New Leaf Production Center, LLC, and is writing this public comment on behalf of New Leaf with regards to a renewal application that was mailed and emailed on August 10th, 2020. The renewal packet was submitted with a cover letter detailing our client's unusual circumstances and need for an expedited decision by the Cannabis Compliance Board. On behalf of our client, we respectfully request that the CCB please take a look at the package that was submitted, and if a decision cannot be made during the August 25th, 2020 board meeting, that the issue please be placed on the agenda as an action item for the CCB's September meeting. Time is of the essence for our clients. Thank you in advance for your consideration. The next public comment is from Shane Terry. I'm writing this letter in support of the proposed settlement agreement and consent agenda item VE2 between TRNVP 098 and High Sierra Holistics. I'm the founder and CEO of TRNVP 098, and just like the settlement agreements that were approved in the previous hearing, we feel like this is another positive step towards resolving an issue that has been a shadow over our industry since the second round of dispensary licensing. I realize the challenges in regards to satisfying all concerns and interests of the parties involved in the litigation, but we feel that not only is this a positive step for our industry's growth, but I also feel that the specifics of the settlement address some of the very concerns that were brought up during this process. Not only does this proposed settlement help free up valuable financial and personal resources that the state of Nevada has had to incur through this litigation, but it also addresses two fundamental concerns in regards to the application process. Number one, that dispensary licenses were not equally distributed to companies that previously did not have a dispensary. And number two, that diversity was not emphasized through the process. As a result of this settlement, not only would licenses be distributed among two companies that did not previously own a dispensary, but allowing TRNVP 098 to keep its remaining dispensary licenses results in dispensary awards going to a company that qualifies as a 100% owned minority and service disabled veteran-owned business in accordance with NRS 75A. I understand that this is just a small part of the equation, but it's also a small step in the right direction for diversity and equality. Accompanying our settlement proposal, all parties have also completed and executed the proper transfer of interest documentation as required by the CCB. As outlined in the settlement, all parties are currently marijuana license holders and have previously qualified through background checks. We would also request that the accompanied transfer of interest documentation be approved at this time in conjunction with our settlement proposal so that all parties can complete the settlement in its entirety and immediately return their focus to creating business that are both impactful to the communities that they serve while also contributing to the continuous growth of Nevada's cannabis industry and state economic recovery. Thank you for your consideration. We're honored to contribute to a resolution that can help put this behind all parties involved. The next public comment is from Kim Rushton. On behalf of Rad Source Technologies, Inc., this correspondence is intended to serve as public comment at the regularly scheduled August CCB meeting with respect to Regulation 12.065. There are several fundamental problems with Reg 12.065, including, number one, Reg 12.065 was improperly considered and approved by the CCB during the July meeting, having failed to meet the noticing standards set forth in Nevada Revised Statute 678A.460. This specific point was raised by Rad Source prior to the July meeting and thereafter in various correspondence sent to the Nevada Attorney General's Office and Executive Director Climates. Number two, Reg 12.065 specifically uses the term radiation. Radiation is the emission or transmission of energy in the form of waves or particles through space or through a material medium. This includes electromagnetic radiation, such as radio waves, microwaves, infrared, visible light, ultraviolet, X-rays, and gamma radiation. Thus, a number of common practices in the cannabis industry, including but not limited to exposure to sunshine and ambient lights, the utilization of grow lights, and sterilization and decontamination processes, use radio frequency and ionizing radiation or radiation. However, despite the CCB's knowledge of the various forms of radiation used in the cannabis industry, Reg 12.065 was drafted specifically in response to a writ of mandamus directing the CCB's predecessor, the Department of Taxation Marijuana Enforcement Division, to immediately cease an arbitrary and capricious ban on Rad Source equipment using X-ray ionizing radiation. Furthermore, despite its inartful drafting, said regulation appeared to intended to apply to only that form of radiation. As such, Reg 12.065 in its current form is not a legally proper regulation of general applicability. Number 3, Reg 12.065 is further flawed in that it applies to food regulations to the cannabis products, and again, only the subset of cannabis products treated using RAD source equipment. The court issuing the writ of mandamus in RAD Source Technologies, Inc. versus State of Nevada Department of Taxation, Marijuana Enforcement Division, has already addressed the state's problem with attempting to apply food regulations to cannabis, which is not food. Number 4, lastly, the CCB is in possession of scientific studies, data, and other reports and information, including the results of a safety study requested from one of RAD's sources, Nevada customers by a certain CCB staff, and conducted using a RAD source machine in Nevada. The next public comment is from Sigal Chata. Dear Commissioners, please accept this objection to Agenda Item C, request for transfer of interest of the below listed companies. The subject transfers are the result of a settlement agreement procured during the course of litigation of the 8th Judicial District Court case in Ray Department of Taxation. These transfers between plaintiffs and interveners should not be approved, as the rankings of said plaintiffs would have precluded them from obtaining licenses under Chapter NRS 453D, which delineates that the applications must have been completed and satisfactory to grant the licenses. It's incomprehensible how the parties with the respective rankings below now somehow qualify to obtain licenses, despite 2 years of litigation by the DOT and interveners, that they would never have qualified, and that the interveners were rightfully awarded licenses. Both the DOT and interveners providing the licenses are judicially stopped from making such representations, insinuating that the below named parties should now be awarded licenses. Accordingly, these companies' requests for transfers should be denied. The companies and their respective rankings for Clark County are as follows. Nevada Pure LLC ranked 65-61. Live Free Wellness ranked 27, Development Company ranked 12 and 11, Qualcan ranked 7, 11, 9, Nevada Wellness Center ranked 754, 69, ETW Management Group ranked 30, 71, 68, Global Harmony ranked 28, 64, 49, 60, Just Quality ranked 29, 68, 65, Libra Wellness Center ranked 32, 95, 70, 85, Ramba Real Estate ranked 49, 41, and Zion Gardens ranked 23. The next public comment is from Amy Sugden. I'm once again writing to you regarding my client, THC Nevada LLC's objection to another last-ditch effort to try and have the CCB rubber stamp a settlement agreement that may be rendered completely unenforceable by the Honorable Elizabeth Gonzalez of the 8th Judicial District when she issues her decision on the 2018 dispensary application process in its entirety. It's expected that Judge Gonzalez will issue her decision on or about September 4th, 2020, less than 8 business days away, and yet here we are on another emergency 3-day notice meeting. Specifically, THC Nevada objects to item C on D on the agenda. Change of requests for ownership have been on hold and or backlogged at the state level for over a year, and now in a grossly self-serving manner, the settling parties in the dispensary litigation somehow get to jump to the front of the line because they have unilaterally designated themselves as most important. This type of preferential treatment to certain licensees over others is exactly what the CCB is supposed to avoid, unlike its predecessor, the DOT. More concerning is how the CCB could have possibly undertaken the due diligence needed to even consider approving these transfers as of August 19th, when the notice for this meeting was posted. The partial settlement agreement at issue was purportedly executed on July 28th, 2020, 22 days. The CCB is representing that it has undergone all the necessary due diligence in 22 days to transfer over 56 licenses as identified on the agenda. This is amazing. Anything that has to be set up on no less than 3 emergency agendas to receive stealth like approval is suspicious. The CCB was appointed to do better than the DOT. We ask you to take that charge and actually execute on it. We ask you to, at the very least, provide supporting materials for your emergency meetings in advance so that the public can intelligently and comprehensively provide input. And sadly, this has not occurred for today's meeting. To the extent that the entirety of the 2018 licensing process should be turned on its head, including nullifying the conditional awards of all the licenses issued, the CCB should be proceeding with extreme caution. Why cannot the CCB wait 8 days until the court is anticipated to make its ruling to see whether or not the licenses that are attempting to be transferred are actually validly held or not? Otherwise, the CCB is at great risk of sanctioning the transfer of rogue licenses and further embarrassing the state. I almost did not write a written response this time because it seemed there was very little to no meaningful actual discussion at the CCB's last meeting voting to approve the partial settlement agreement. I'm erring, however, on the optimistic side of caution that someone will actually take the time to consider the public comments. The last public comment is from Cassandra Didis. My name is Cassandra, and my comment today is in support of Chairman Nylander's previous commentary during review of the proposed regulations. During this review, Mr. Nylander gave insight that the chain of process for complaints before they are brought to the attention of the board members has a distinct need for clarification and request for transparency through this process. If the CCB board is to have transparency and stand on the side of impartial review of documentation provided in complaints, the review of complaints done solely by the executive director and allowing of the decision to be made under that position alone has created the same problem the tax department had under the direction of Jorge Pupo at the helm of the Nevada Cannabis program. Mr. Pupo's improprieties and the extent of his actions have yet to be seen how deep the rabbit hole will go. As we speak across the U.S., federal agencies have begun to spike due to the corruption of actors such as Mr. Pupo, taking liberties with public positions of trust. As Governor Sisolak came to office and dove headfirst into the issues condemning the handling of the cannabis program operations that gave way to the CCB board, Nevada has begun to dub itself the gold standard in cannabis oversight under the concept that this board will thoroughly review everything associated with possible improprieties. If the board is required to have layers between them and potential reports of violations, how are they to be the face of and attest to upholding those values if they do not know what they don't know? In no reflection of Mr. Klimas and solely in reference to the actions of Mr. Pupo, the process leaves a gaping hole in which one person is at the helm of the administrative department and the sole party responsible for deciding whether a complaint filed to the board will even be seen by its members, let alone let them have the chance to review and decide the course of action upon the complaint. To my understanding, the purpose of the board and its seated members was to provide an impartial grouping of educated members to review and collaborate on whether an issue deserves further investigation. The action of permitting that task to remain under one person's authority is perpetuating the already massive problem that tax department had in the first place. This leads to the thoughts that surrounding the approvals of the licensees slated on the agenda today. There's currently a large amount of information that has been provided to CCB regarding the need for review of this decision in depth and in entirety of the complaint, and a deep need to be reviewed by the actual board before approval. Regarding the licenses of the agenda for final approval, though they aren't in litigation at this time like so many of Mr. Pupo's licenses. These licenses specifically stem from another instance under the authority and guidance of Mr. Pupo, and specifically, that is it.
Thank you, Ms. Bonner. Moving on to agenda item number 2, approval of the minutes. This is the consideration for approval of the July 21st, 2020 Nevada Cannabis Compliance Board meeting minutes. Chair?
Can't hear anything after, hello? After Mr. Kleinis's comments, I could not hear anything.
I'm sorry, I didn't have my mic on. This is the time set for the approval of the minutes from the July 21st, 2020 meeting. If the commissioners have no additions or corrections, if we can have a motion for approval of the minutes.
Jerry Merritt, for the record, so moved.
Dennis Nylander, for the record, I would second the motion for approval.
We have a motion, we have a second. All in favor, please say aye.
Aye.
Aye. Motion's been carried.
Great, thank you. This is Tyler Klimas for the record. Moving on to agenda item number 3, status of medical and recreational cannabis license renewals. Chair, you made a request at the last board meeting to receive an update on the current status of license renewals. So I'll now provide a brief summary of renewals and detail some of the obstacles and outstanding obligations we found this year while processing renewals. Following this report and this agenda item, we'll have compliance investigator Rachel Branner from the CCB provide the board with a more detailed overview of tax fundamentals and tax requirements of licensees. This should help further clarify some of the issues that came up during renewals. So Chair, members of the board, do you have any questions before I get started on the summary?
Chair Douglas, I have no questions.
Okay, great. As a refresher, the CCB currently processes all license renewals, more than 700 for all establishment types for both medical and recreational licenses. Although various licenses are up for renewal in every month of the year, we have an overwhelming portion of the renewals due by June 30th, around 560, due to the issuance of final licenses during the one-for-one licensing round in 2017. During the renewal process this year, as duties transferred to the CCB from the Department of Taxation, we found a number of outstanding tax obligations existed throughout the license types with varying levels of severity. For example, out of all licenses expiring on June 30th, 11 licensees representing 22 licenses had not submitted a renewal fee or a renewal application well into July. We did not renew these licenses and instead sent correspondence indicating that Metric Access would be shut off immediately if they did not respond and remedy the situation. This correspondence resulted in one licensee surrendering its distribution license and the others fulfilling their financial obligations for the renewal and application submissions. Additionally, we found 18 licensees representing over 48 individual licenses that had outstanding tax obligations and or missing tax filings. These obligations included everything from outstanding sales and use tax, wholesale marijuana tax, modified business tax, and retail marijuana tax filings, tobacco taxes in the amounts ranging from $500 to $4 million. Some of these obligations dated back to March of 2019. Again, staff sent correspondence to all parties indicating that their license would not be renewed and Metric Access would be shut off if they did not immediately move towards compliance. I can now report that as of today, all of the parties have either paid their outstanding balances in full or have entered into or are in final negotiations to enter into payment plans with the Department of Taxation. This is a step that must be completed before the CCB will ever consider renewing a license. Moving forward, the CCB staff will begin sending notices indicating licensees are out of compliance immediately following the license renewal due date if any taxes are outstanding. Metric Access will also be shut off, preventing a licensee from doing any business if the licensee fails to cure. Additionally, NCCR Regulation 5.095, which the board adopted at its July meeting, states that a licensee must cease operations if it fails to renew its license by the expiration date, and the license will be deemed voluntarily surrendered if the license is not renewed within 90 days of the expiration date. With these guardrails in place, CCB staff now has the tools to ensure licensees understand that full compliance, including any tax obligations, must be fully resolved before a license renewal will be considered. So with that, I will answer any questions from the board. Again, Ms. Branner is here to give a tax primer for the board members immediately following this agenda item. Chair.
Commissioners, any questions, Mr. Klimas?
No.
No,
questions?
thanks for that.
If we can have our next portion.
Great, thank you. So moving on to agenda item number 4, we have Rachel Branner here. She's a compliance audit investigator 2. She'll now present an overview of the different tax types cannabis establishments may be responsible for remitting to the Department of Taxation.
Good morning, Chair, board members. My name is Rachel Branner. As Director Klimas just indicated, I'm a compliance investigator with the CCB. I'm also a former Department of Taxation employee. I was with them for 9 years as a revenue officer, which is basically just a fancy way of saying tax collector. There are multiple different tax types that cannabis establishments may be responsible for collecting and remitting to the Department of Taxation. Even though the Cannabis Compliance Board took over the licensing and regulatory duties from Department of Taxation, the Department of Taxation continues to collect the taxes owed by cannabis establishments. The Department of Taxation provides monthly updates to CCB staff regarding establishments with tax compliance issues. Below is a brief snapshot of each tax type that cannabis establishments may be responsible for, as well as discussion on repercussions for the cannabis establishments that fail to timely file, collect, and pay taxes. First up, we have commerce tax. This is an entity-level tax. It's due once a year, 45 days at the end of the fiscal year. Fiscal year end date is June 30th, so the return is due on or around August 15th. It is due on gross revenue received from transactions that occurred within the state of Nevada. Entities with gross revenue that is less than $4 million are not required to file. Tax is imposed only on the amount of gross revenue in excess of $4 million. The tax rate is contingent on the entity's North American Industry Classification System Code, or NAICS code. Another tax type that our establishments need to be familiar with is modified business tax. It is an entity-level tax due quarterly, 30 days after the end of the reporting period. So quarter 1 is due April 30th, quarter 2 is due July 31st, quarter 3, October 31st, and quarter 4, January 31st. It is a mirror to unemployment insurance. This tax is due on gross wages paid during the calendar quarter for all locations that are owned by that entity. Gross wages reported on the return should match the gross wages reported to the Employment Security Department for the same quarter. Tax is imposed on the amount of gross wages in excess of $50,000. And the tax rate is contingent on that business's industry, whether that be mining, finance, or general business. The most common kind of tax that our establishments should be familiar with is sales and use tax. And technically, those are two different types of taxes. They are reported on the same return, and it is a location-specific tax. Entities with multiple different locations can request to file one consolidated sales and use tax return to reflect the taxes due from all locations. It is based on their gross sales. Returns are either due monthly or quarterly, 30 days after the reporting period. So January's return would be due February, February's would be due March. For quarterly filers, it would be very similar to modified business tax. First quarter would be due April 30th, second quarter, July 31st, etc. Sales tax is due on the sale of all tangible personal property where transfer of possession or ownership occurs within the state of Nevada. The tax rate is contingent on the county in which the transaction took place. Sales tax is collected from the end user or the consumer, the customer, at the time of sale. It is considered trust money. It is held in trust by the establishment for the state of Nevada and to be remitted to the state of Nevada. Certain transactions can be exempt from sales tax. Wholesale transactions where a resale certificate has been presented to the seller Certain items of tangible personal property are also exempt from sales tax. Those things are like durable medical equipment, those sorts of things. Use tax, not everybody is familiar with. It's an accompaniment to sales tax, and it is due on the purchase price of all tangible personal property purchased to be used or consumed in the state of Nevada, where sales tax was not assessed. So for example, if an establishment purchased supplies like totes or a computer or something of that nature, and sales tax was not assessed by the vendor at the time of purchase, use tax is due on that purchase price. The tax rate is, of course, contingent on where that item is being used or consumed in the state of Nevada. For our more marijuana-specific taxes, we have wholesale marijuana tax. Again, this is a location-specific tax. It is due monthly, 30 days after the end of the reporting period. It is due on the first wholesale sale of marijuana or marijuana products, and it is assessed on the fair market value of the product that was sold. Fair market value is calculated by Department of Taxation every 6 months based on the reported sales of marijuana and marijuana products. Different products have a different fair market value, and the tax rate for wholesale marijuana tax, excuse me, is 15% of the fair market value. Retail marijuana tax, again, is a location-specific tax. It is due monthly, 30 days after the end of the reporting period. It is collected from the end user or the consumer at the point of purchase. The tax rate is 10% of the sales price of the marijuana or the marijuana products. It does not apply to marijuana paraphernalia, so things like papers, grinders, water pipes, those kinds of things. It also does not apply to other items of tangible personal property, things like t-shirts or hats or backpacks or those kinds of things. Retail marijuana tax must be separately stated on the receipt. With all these types of taxes, there are regulatory repercussions for those who fail to timely file, pay, and remit taxes to the Department of Taxation. One of those is penalties and interest. When a return is filed late or with partial or no payment, penalties and interest are assessed. It is a one-time penalty up to the tax balance, up to 10% of the tax balance that is due. It is a graduated penalty based on how late the payment is received. So if they file and pay a return like 2 days late, they pay a smaller percentage of that penalty than if they let that return be over 30 days late, at which time the full 10% penalty would be assessed. Interest is assessed at the rate of 0.75%, so 0.75% monthly on the tax portion of the unpaid balance. That 0.75% is assessed on the first of each month after the due date, and interest does not accrue on interest or on penalties. A waiver of penalties and interest can be requested in certain circumstances. Payment plans can also be requested by establishments with outstanding tax liabilities. There are several requirements that the establishments must meet. All of the delinquent or missing returns must be filed. A written request for a payment plan must be submitted, along with an initial payment plan payment. 2 owners or officers must sign a payment agreement and payment agreement guarantee, which guarantees that the establishment will timely file and pay all future tax returns, and that all payment plan payments will be remitted timely with good funds. So, thank you. So no return checks. Entity and personal liens will also be placed to secure the outstanding liability. And entity and personal financial statements, similar to the ones that the IRS requests, may be required with attachments. Those attachments can include mortgage statements, bank statements, payable statements, profit and loss or an income statement. If the payment plan will take longer than 12 months, or the tax portion of the liability is over $50,000, the Nevada Tax Commission must approve that payment plan. Civil penalties are also assessed on cannabis establishments that have failed to meet their filing requirements with the Department of Taxation. Intentionally failing to file, pay, or properly collect taxes is a Category 1 violation. Unintentionally failing to file and or pay taxes is a Category 3 violation. Intentional versus unintentional failure to file and pay is not defined by Department of Taxation. Returns that are late filed, late paid, or delinquent, meaning unfiled and unpaid, are considered to be done so intentionally. However, when considering a waiver of penalties and or interest, statute indicates that late filing and or late payment of a return has to meet certain parameters for the tardiness to be considered unintentional and thereby qualify for a waiver. Those parameters are circumstances that occurred beyond the business's control, that occurred despite the exercise of ordinary care and without intent. So something like sticking your payment in the post office and then the post office explodes. They obviously did what they were supposed to do, just that was beyond their control. That is it for my tax fundamentals for cannabis establishments. Are there any questions?
Commissioners? I would thank you for the report. My question probably is more directed at
Chair Douglas, I'm sorry, I cannot hear you, Chair Douglas.
Chair Douglas. Thank you for the presentation. Unless there's any questions, my question will be directed at our director, Mr. Klimas. Do we have an apparatus, because this information is more for the licensees, but from our standpoint, how are we notified if there is a tax delinquency? Is that coming directly to us, or do we have to reach out to the tax folks to get that information?
Thank you for the question, Chair. This is Tyler Klimas for the record, and you're really, I think, getting at the heart of where these issues were, and that was on communication, potentially somewhat of a communication breakdown. And so much of this going forward, the effectiveness of our efforts here going forward is going to be that communication between the CCB and the Department of Taxation. We have strong relationships with the Department of Taxation. We have talked about monthly and agreed upon monthly reports indicating who may be behind on filings and tax, and then actual, quarterly updates on who is behind. And so that's where our efforts are going to be focused on, so that we can be proactive. And again, Chair, this year it was on renewals, but we're not going to wait until your license is up for renewal to check in on tax compliance or take any kind of regulatory action on tax compliance. So by having monthly meetings and quarterly reports between the two agencies, we'll be able to better track this and be on top of it.
Any questions any of the commissioners have? If we have none, we will move the agenda to item number 5.
Am I on? Okay. So moving on to agenda item number 5. This is the consent agenda. We'll start with 5A. These are the complaints. Chair, on the agenda, there are 9 complaints for disciplinary action. Pursuant to NRS 678A510, the Attorney General has reviewed these violations and has recommended proceeding with disciplinary action. I'll now present the violations alleged and request the board vote to authorize the service of a complaint for disciplinary action for each licensee. 5 of these complaints seek discipline on an individual's agent card. The other 4 complaints are for discipline against cannabis establishments. As to licensee A, the complaint will allege 7 violations of NAC 453D. As to licensee B, the complaint will allege 3 violations of NAC 453D. As to licensee C, the complaint will allege 2 violations of NAC 453A and 6 violations of NAC 453D. As to licensee D, the complaint will allege 1 violation of NRS 678C, 4 violations of NAC 453A, and 6 violations of NAC 453D. As to licensee E, the complaint will allege 1 violation of NAC 453A and 14 violations of NAC 453D. As to licensee F, the complaint will allege 5 violations of NAC 453D. As to licensee G, the complaint will allege 5 violations of NAC 453D. As to licensee H, the complaint will allege 5 violations of NAC 453D. As to licensee I, the complaint will allege 5 violations of NAC 453D. Chair, I'll now turn the item back to you.
We've had the report that we are to receive pursuant to the revised statutes for complaints to be issued. These are on the consent item. Unless a commissioner wants one of the items removed, can we have a motion to accept the complaints for action?
For the record, this is Jerry Merritt. So moved, Chair.
We have a motion. Do we have a second?
This is Member Nylander. I would second the motion for approval of service.
We have a motion. We have a second. All in favor, please say aye.
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 Aye. Motion has been carried. That item A under consent has now been approved. I would just note that we had a note under our public comment as to the propriety of this exercise. Last meeting, as was outlined, we voiced some of our reservation. However, this is a process that has been set forth by the Nevada legislature, and that is the process we must follow going forward. There's some other things, but that may be something that we look at for legislative action next session. Having said that, we would move to B, request for withdrawal or transfer of interest. If we can have our presentation, please.
Good morning, Chair Douglas, Member Merritt, and Member Nylander. For the record, I am David Staley, Chief Investigator for the CCB. I'm excited and proud to appear before you today to present 12 transfer of interest or TOI applications for your consideration. Excited because we've been working on the TOI process since I began assisting the CCB in January of this year, and because it means we're making progress in processing the applications impacted by the extended review period. Proud because the work of your 3 investigators, Rachel Branner, Jeff Justice, Ashley Liano, as well as Steve Gilbert, the work they've done in completing the TOIs. They all jumped right into a process that none of them had any experience before and performed well beyond my expectations. I would also like to point out that these TOI investigations are another way that the CCB is complying with NRS 678A-480, which requires the CCB to conduct financial and/or operational audits of our licensees. I'm here to present agenda item number 5B, which consists of 6 requests for withdrawal of TOI applications due to various requests made by the applicants. Staff requests that item number 4, Fine Cannabis Dispensary LLC, be referred back to staff for inclusion on the September board meeting. I'm available to answer any questions regarding the withdrawals before you, and with that, Chair Douglas, I will turn these items back to you.
Thank you for the report. Commissioners, any questions? If no questions as to the withdrawals, if we can have a motion for acceptance of this consent item.
Mr. Chair, this is Member Nylander. I would move that we grant these withdrawals as stated on the agenda item number 5B.
Chair, for your record, this is Jerry Merritt. I second.
We have a motion. We have a second for request for withdrawals. All in favor, please say aye.
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 Aye. Motion's carried. That would move us to request item number C under consent, request for transfer of interest.
For the record, Dave Staley, Chief Investigator. I'm here to present agenda item number 5C, which consists of 6 TOI applications. Item number 1 is the TOI application for Nevada Pure LLC, in which Nevada Pure has requested approval for an existing shareholder, Gary Rexroad, through his company RMC Pure LLC, to purchase 6% ownership of Nevada Pure from other existing minority shareholders. Staff identified no areas of concern with this application. I am available for any questions, and my understanding is that several representatives from Nevada Pier are present today via Zoom to address any questions you may have as well. With that, Chair Douglas, I turn this item back to you.
Why don't we go through each one of these items, and then if the commissioners have any specific questions, they'll ask.
Yes, sir. So we're on to item number 2?
Yes.
Okay. For the record, Dave Staley. Item number 2 is the TOI application for Live Free Wellness LLC, in which Live Free has requested approval for the acquisition of adult use cannabis retail license RD 547 from Helping Hands Wellness Center, Inc. Staff suggests that if the board approves this TOI, such approval would be conditioned to require written attestation from Live Free that its operation of RD 547 will meet or exceed the merits of the operation specified in the original application submitted by Helping Hands. Board members, I think yesterday, Director Klimas should have given you a separate sheet with our proposed conditions on them to help in applying them to the different TOIs. Item number 3 are TOI applications for Planet 13 Holdings, Inc. through its subsidiary Development Company, Inc., in which Planet 13 has requested approval for the acquisition of cannabis cultivation licenses C067 and RC067 and cannabis production licenses P034 and RP034 from West Coast Development Nevada, LLC. Planet 13 also requests approval for acquisition of an adult use cannabis retail license number RD215 from Nevada Organic Remedies, LLC. In addition, Planet 13 has requested a waiver pursuant to NCCR 5.112 of the requirements of NCCR 5.110 regarding a review of all Planet 13 shareholders. Staff would like to point out that Planet 13 has submitted the names and addresses of all shareholders that own over 5% of its common stock and all of its officers and directors, some of which hold as little as 0.07% of Planet 13 shares. Staff suggests that if the board approves this TOI, such approval be conditioned to require written attestation from Planet 13 that its operation of RD215 will meet or exceed the merits of the operation specified in the original application submitted by Helping Hands. Staff also suggests that if the board approves the waiver of NCCR 5.112, that the waiver be conditioned to expire upon the consummation of each of these transactions. Item number 4 are TOI applications for Mystic Holdings, Inc. through its subsidiary Qualcan, LLC, in which Mystic Holdings has requested approval for acquisition of an adult use cannabis retail license number RD591 from Nevada Organic Remedies and from Nevada Organic Remedies, LLC, and RD222 from, I got that wrong, number 5, RD591 from Lone Mountain Partners, LLC, and RD222 from Nevada Organic Remedies, LLC. Staff suggests that if the board approves this TOI, such approval will be conditioned to require written attestation from Mystic that its operation of RD591 and RD222 will meet or exceed the merits of the operation specified in the original applications submitted by Lone Mountain and Nevada Organic Remedies. Was there a question? Okay. Number 5 is a TOI application from Nevada Wellness, LLC, in which Nevada Wellness requests for approval for its acquisition of a cannabis retail license held by Green Mart of Nevada, NLV, LLC. The transferee is Nevada Wellness Center, and they have requested that this application move forward on this agenda. Green Mart, the transferor, has requested a continuance of this item to be heard at the September agenda. The application was filed by Nevada Wellness, not by Green Mart. Green Mart has not yet signed the So if the requested TOI application is approved, the CCB staff recommends that the approval be conditioned to require Greenmart to provide a signed and notarized transfer of interest form as transferor before the transfer of a license can occur. In addition, the CCB staff recommends that the approval be conditioned to require Nevada Wellness to provide a written attestation that the operation of the adult use cannabis retail license acquired from Greenmart will meet or exceed the merits of the operations specified in the original application submitted by Greenmart. And lastly, item number 6 are the applications for the ETW group in which Conjurium LLC, a wholly owned subsidiary of the individual members of ETW Group, has requested approval for the acquisition of adult use cannabis retail licenses number RD 593, 594, 697, and RD 602 from Lone Mountain Partners LLC, and number RD 266 from CPM Holdings LLC, Cheyenne Medical LLC, and Commerce Park Medical LLC. Staff suggests that if the board approves this TOI, such approval be conditioned to require written attestation from Conjurium that its operation of RD 593, 594, 567, 602, and RD 266 will meet or exceed the merits of the operation specified in the original application submitted by Lone Mountain and CPCM Holdings LLC, Cheyenne Medical LLC, and Commerce Park Medical LLC. I'm available for any questions that board members may have. My understanding is that various representatives from each of the TOI applicants are available through Zoom to address any questions you may have as well. With that, Chair Douglas, I'll turn this item back to you.
This is Chair Douglas. Commissioners, before I say anything, any of you have any questions you wish to pose to Mr. Staley?
Mr. Chairman, this is Member Nylander. Just a more broader question for Mr. Staley. If you could spend just a few minutes outlining the investigative process and the investigative reports that the board members have received. This is really the first time we've seen a robust investigative process for these transfers of interest. So, and I'm not asking a question specifically on anyone, but just the process.
Yes, sir. Chair Douglas, members Merritt and Nylander, for the record, this is David Staley. The investigative process involved kind of two different steps. The first step is that one of our investigators, Jeff Justice, has worked on a worksheet that we use in which the investigating agent will conduct background checks through as many different types of checks that we might have available: LexisNexis, Thomson Reuters. There are also searches done on public media, Google, Facebook, the Nevada Secretary of State office, as many different avenues as we've been able to come up with through our ability as an agency to do these background investigations, coupled with the executives and the material shareholders on these entities undergo the typical background investigation associated with the fingerprint submission. Part of our review as well is reviewing the applications and, more importantly, reviewing any of the agreements or contracts between the two parties, the transferee and the transferor, in which case we're able to kind of identify and ensure that the parties are the licensed entities. We'll be able to better understand the transactions. We review the ownership that we have in our records and compare that to the ownership that they've submitted to us, either as a public company through their public filings or through as a private company through the filings that they submit to us directly. The reports that you see before you do not include the specific results of the litany of individual checks that our agents do. If you see nothing specific, then that generally indicates that the background investigation came back clean and we had no material issues. If there are issues, they would be detailed in the investigative report to give you more information to draw upon as you make the decisions that you have before you. The investigative reports are in part to help. I'm new to this industry, so a lot of this is education for myself. It's also exposing you, the board members, to this new industry, not knowing the level of comfort level that you have with the cannabis industry and who does what. This is a way to start providing the baseline by which the CCB can start looking at this industry. And part of that is understanding who the players are, who the licensees are. Another component that you'll see primarily in transfer of interest applications, not in withdrawals, will be the review and analysis of a rather abbreviated income statement balance sheet for these entities. Again, this is a process that is new to your investigators. We will build on that until we start doing debt analysis as well as some level of ratio analysis that will help us understand better the financial health of the company, which will then lead to a better understanding of its operations. And we're able to get a better feel perhaps for how they intend to use the new licenses or operations that they're acquiring. Member Nylander, does that cover the points that you needed?
Yes, thank you, Mr. Staley. That's very helpful. I do appreciate that this is new to everyone, and I believe the framework is in place to have a very robust investigative work product for the benefit of the board, and I do appreciate that. Thank you.
Thank you.
For the record, this is Jerry. I also agree. That was very helpful.
Thank you, Member Merritt.
This is Chair Douglas. As to what was submitted to the board, and it's on for consent, but before we get to that, my question was as to M&M or development.
Development or Planet 13? 13.
They have a number of individuals who are less than 5% shareholders. And they, if I understand correctly, they supplied their names. They didn't supply addresses as required. They are also requesting a waiver of any investigation.
Yes, sir. They submitted the names and addresses of all of their owners and officers down to, as I mentioned, 7/100%. And they have requested a waiver of NCCR 5.112 in relation to the public shareholders of Planet 13.
Could they provide us with a reason why they are requesting that waiver?
I would defer to I believe Leighton Kohler is present for Planet 13, and I believe that he had an explanation for that request.
I'm concerned that at a minimum, are we still on? This is Chair Douglas. I'm concerned at a minimum that we require that name and address. We have names, we do not have address. It would seem that in this sophisticated world of information, the address would not be that difficult to provide in this particular case. As to item C under request for transfer of interest, I would like to see us take items 1, 2, 4, 5, and 6 consent with the conditions that were outlined by Mr. Staley for the record.
Chairman, this is Leighton Kohler on behalf of MM. Can you hear me?
Yeah, please hold off right now. And I would like to have those items taken um, as a group for consent, and we would take M&M separate.
Yeah,
If that's
Mr.
okay.
Chairman, this is Member Nylander. I was curious about what you thought about item number 5. It appears that, and I apologize if I misunderstood, but I know it seemed you wanted to include that in this group, and there seems to
And
be some missing documents on that item.
And that would be the condition, as Mr. Staley indicated, and you're correct, we need more specific for the record, that the documents that have to be signed are provided to the compliance board, and that we would be giving them a conditional approval subject to those missing papers coming in. Once they come in, the license would be in full.
Yes, sir.
Okay.
Those are the conditions that staff is suggesting for item number 5.
Is that responsive, Mr. Nylander?
Yeah, that clears it up. I just wasn't sure if you wanted to refer it back or have it go forward. I'm comfortable either way.
Well, this way, it would seem to be in order, subject to those signed documents not being provided. Once they could be provided, that would be the condition that we would add.
Okay.
So with the exception of M&M, do we have a motion for approval of this consent item at this time?
Mr. Chairman, would you like me to take them one at a time and read the
We can take
conditions into the record?
We can take them one at a time, and we can do that for the record.
Okay, well, we'll begin with item number 1. I would move for approval of that item. There were no suggested conditions from staff, and I didn't have any questions or concern based on the investigative reports. Do you want me to do them all at once, Mr. Chairman, or take them or vote on the motions one at a time?
Whatever your preference is.
I'll take them all at once. With respect to item number 2, I would move for approval. That transfer of interest approval would be conditioned that Live Free Wellness must provide a written attestation that the operation of the adult use cannabis retail license, number RD 547, acquired from Helping Hands Wellness Center, will meet or exceed the merits of the operations specified in the original application submitted by Helping Hands Wellness Center. And we're going to hold out item number 3 for further discussion. And then with respect to item number 4, I would request that, I'd move for approval with the recommendation and a condition that Mystic Holdings, Inc. provide written attestation that the operation of the adult use cannabis retail license, RD 591, acquired from Lone Mountain Partners, LLC, will meet or exceed the merits of the operation specified in the original application submitted by Lone Mountain Partners, LLC. And we also have a recommendation here that an additional condition that Mystic and Lone Mountain provide a signed and notarized transfer of interest reform. And then further, with respect to this is a multiple transfers, we would condition it that Mystic Holdings provide a written attestation that the operation of the adult use cannabis retail license, number RD 222, acquired from Nevada Organic Remedies LLC, will meet or exceed the merits of the operation specified in the original application submitted by Nevada Organic Remedies LLC, and further condition that Mystic Holdings and Nevada Organic Remedies provide a signed and notarized transfer of interest. And then with respect to item number 5, and that would be Nevada Wellness Center, I would move for approval. With that approval will be conditioned that the missing documents that are necessary to complete the application be provided to the CCB as a precondition of that transfer occurring.
Member Nylander, there's also a suggested condition regarding the attestation by Nevada Wellness on that item as well.
Okay, so that would also be conditioned that Nevada Wellness attest that that the transfer will meet or exceed the merits of the operation specified in the original applications that were submitted. And then with respect to item number 6, I would move for approval. That would be conditioned that Conjurium LLC provide a written attestation that the operation of the adult use cannabis license numbers RD 593, RD 594, RD 597, and RD 604 acquired from Lone Mountain Partners LLC and RD 266 acquired from CPCM Holdings LLC, Cheyenne Medical LLC, and Commerce Park LLC will meet or exceed the expectations and merits of the operation specified in the original applications.
Okay, we have a motion for approval of items 1, 2, 4, 5, and 6 with conditions so stated. Do we have a second for?
Mr. Chair, Jerry Merritt, for the record, I second.
We have a motion and a second for approval. All in favor, please say aye.
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 Aye. Motion's been carried with conditions as to 1, 2, 4, 5, and 6. Now taking item number 3, M&M Development Company. We had a request from M&M Development to speak for the record. Still there? M&M?
Chairman Douglas, Commissioner, I am here. Chairman Douglas, Commissioner Nylander, Commissioner Merritt, thank you for the opportunity to provide comment. For the record, this is Leighton Kohler, officer and board member responding on behalf of licensee MM Development Company, Inc. Robert Grossbeck, founder and president, is present with me today.
Good morning.
Good morning. Good morning. So I've prepared a brief summary of some of the great difficulties that a public company would undergo and some of the impossibilities that are present in the event that a complete list of names and addresses is required. With your permission, I'd like to provide that summary.
This is Chair Douglas. Yes, please do so. Please understand this morning, we are navigating the new requirements and trying to deal with the waiver issue and the new situation of publicly traded companies with numerous shareholders under 5%. So that's why we're trying to be careful. I hate to say you're the textbook case for us looking at how we're going to go forward, but you seem to be that this date. So I'd appreciate any information you can give us.
Thank you, Chairman. We're happy to be of service. So launching right in, just like with public gaming companies, Planet 13 as a public company uses outside services to maintain a registered stockholder list. Limited information is available on that report. Typically, a registered stockholder list will have a list of direct owners and then a list of depository accounts held through major depository systems or through banks and brokers. In Canada, where we are publicly traded, this means CDS, CEDE, and indirectly through CDS, DTC. These are acronyms for the largest and most reputable depository account systems. Within the depository accounts, individual stockholders elect to be classified as non-objecting beneficial owners or objecting beneficial owners. The acronyms there are NOBO and OBO. The NOBO-OBO concept arises out of the U.S. Securities and Exchange Commission in the 1980s, out of a need to balance public company and regulatory need to contact the investor and the investor's desire for privacy. The vast majority of shares in Planet 13 are held by large institutional investors. And when I say vast majority, I mean the vast majority of objecting beneficial owner stockholders, meaning stockholders that we don't have ability to see their name and address. Thus, Planet 13 has no capability to obtain that information on those under 5% investors. Further complicating the fact is that when an individual investor wants to trade shares, they do so through a third-party intermediary, broker, or banker who contacts the stock exchange. Planet 13 is listed on the Canadian Stock Exchange, the CSE. In the U.S., an investor may choose to invest in Planet 13 through a broker-dealer trading platform that interfaces from the U.S. to the Canadian Stock Exchange. This is called an over-the-counter trade and is regulated by the SEC. That's an OTC market where Planet 13 is also listed. Despite being a small cap public company, the volume of daily trades makes tracking individual owners an impossible task on a day-to-day basis. For example, yesterday, Planet 13 had daily trade volume of 1.6 million shares traded and an average 30-day volume of 2 million shares per day traded, approximately. On the Canadian Stock Exchange yesterday for Planet 13, ticker symbol PLTH, Planet 13 had a daily volume of 973,000 shares traded and an average volume of 671,000 shares traded per day. Many of these trades are day traders that pop in and out of ownership, and they have no level of control over the company. They're gone before any of their ownership would even matter. It is for this reason that public companies pick a list of stockholders as of a record date and send out an annual shareholder meeting request. This is a snapshot of the registered shareholder list as at market closing on the record date. Shareholder data, in this case, for the non-objecting beneficial owners or stockholders, is aggregated by a service provider, Broadridge, who provides these services for most public companies, including public gaming companies, and they provide the NOBO list so that the company can send out a mailing of the annual circular. So I've given you a rundown. That's kind of, there's a lot of information there. So I'd like to stop and ask, do you have questions about how very difficult it is, and in some cases impossible, for Planet 13 as a public company to provide the name and address of every stockholder?
I have to still repeat my concerns. This is Chair Douglas for the record. Noting from your information, you have 50.37% ownership from various stockholders who you have so listed. And then you have non-management employees at 0.27, but then you have public shareholders at 49.37, which is a large portion, almost 50%. We have been tasked by the state to make sure that owners in this industry meet certain requirements. And they've given us the ability to waive requirements as to 5%, but they put a very low threshold on as to names and addresses. And even though it might be cumbersome from my way of thinking, at least having minimal information so that if some name and location might perk an investigator or a board member's interest as to background and meeting all those requirements, we are kind of left in the dark. And this being in some cases, new information and whatnot, and we are not at the same level at this time as the Gaming Control Board. We are still trying to figure out our way in this. I'm concerned because in this day and age, it seems that you can press a computer and you can get almost any information. And I know at the end of the day, these individuals are investing because they expect a return of their investment, which means someone has their name, address, and other information. And all we are looking at is wanting name and address. And it would seem that that is very doable, but that is just my naivete at this time. Now I'm trying to find out if that is a reasonable expectation or if it's something that is just so difficult that it can't be done. I'm kind of at the feeling, I heard what you said, but I am concerned still. I don't wish to hold up the transfer. However, I would still like that information. I don't know how the other board members feel. They may not be as concerned, so I would leave it to them to weigh in on this and whether or not we would be asking for you to, in a reasonable time, 120 days or something of that nature, provide that information as to addresses of, as you said, the so-stated publicly traded individuals. That's
Chairman, if I may, this is, I'm sorry, I apologize. Chairman, if I may, I think I have some items to offer. For the record, this is Leighton Kohler. At the end of last week, we proffered the NOBO list, which is a list of all shareholders who have provided their name and address and contact information to the AG's office. And we renew that offer, and if that's a condition, that is something that we can meet currently. We prepared that list and offered it in anticipation of this requirement by you. Those lists can be requested going forward. There is a burden there, but our understanding currently is that it's $5,000 or under for a company of our size to request the current NOBO list. I want to clarify that for a public company, we cannot obtain the OBO list, which is the objecting beneficial owner, and that's similar and just like public gaming companies.
Chair Douglas, thank you. Commissioner Merritt or Commissioner Nylander, and Mr. Nylander, you're on gaming, so you might have a different perspective.
Mr. Chair, I would agree with you. Yes.
Mr. Chairman, this is Member Nylander. I share your concerns. Gaming evolved over the years to where the gaming regulations begin to mesh with the Securities and Exchange Commission regulations and other securities regulators throughout the world. And generally speaking, there is a 5% threshold where there is no reporting requirement below the 5%, other than an annual list of stockholders, which is what he's describing. And I think it's kind of unique. The OBO list, which on some level does exist in the US as well. And so while I think we should try to get as much information as we can, I also do recognize that below 5%, it is in some cases impossible. And but at least for the ones that are NOBO, I think we should request those lists on an annual basis and have the initial list submitted. And I guess we could apply a condition to the license that going forward, the annual list be provided to us, disclosing as much information as the company can reasonably attain.
I can't hear you.
This is Chair Douglas. We had a silence there for a while on the mic. I would agree with Commissioner Nylander. Reference the secondary list and the 5% issue. It seems that M&M was moving in that direction to provide us with the information they could. M&M, anything additional you would like to say at this time?
We appreciate your consideration and request you consider approval for item C3 on the agenda. Conditioned on the motions that and the comments that you've made. And we are happy to provide the no-vote list as you've requested.
Thank you. As item number 3, if we can have a motion for conditional approval with the additional lists at this time. And
Mr. Chair, this is Member Nylander. Did you want to condition the production of the stockholders list, including the NOBO list, going forward on an annual basis?
yes, we would.
So we could tie it to today, potentially. And then we have 2 other conditions that staff has suggested as well. And so would you want to include? Yeah, the attestation and also the waiver, whether to grant the waiver.
Give the number list now. Chairman and Commissioners, this is Leighton Kohler for the record. We do have one request. To the extent that we will be having an annual requirement to provide the NOBO list, we would request that we do that as of our record date for our annual shareholder meeting.
We'll do the new list now.
And also confirm that we'll provide the list for the current transfers concurrent with this transfer before you now.
What is your annual, this is Chair Douglas, what is your annual meeting date?
We just, Chairman Douglas, Leighton Kohler for the record, we just had that meeting on June 24th, and approximately that time every year going forward, it will be repeated.
Thank you.
Mr. Chairman, this is Member Nylander. One additional question of Mr. Kohler. Under Canadian securities law, what is the delta between the record date and the annual meeting date?
Commissioner Leighton Kohler for the record, I believe that was 30 days. I'll have to check with our Canadian Securities Council, but we sent out our list 60 to 30 days in advance of that date. And I will provide a record date was 5/23, so it was a month in advance. 30 days is our requirement.
Okay, thank you for that. I was just trying to compare it to the SEC requirements here, which are basically the same, it sounds like. So I'm comfortable with that.
Mr. Nyland, do you have to rephrase your motion at this point?
Yeah, I'm going to start over and I'll just make it easier. And I'm sorry, Member Merritt, if I thought I might have cut you off. I apologize for that.
Oh, no problem at all, please.
Oh, okay.
Go ahead.
Okay, I'll give it a whirl. So with respect to item number 3, Planet 13 Holdings, Inc., I would move for approval. That approval would be conditioned that Planet 13 Holdings, Inc. provide a written attestation that the operation of the adult use cannabis retail license number RD215 acquired from Nevada Organic Remedies, LLC, will meet or exceed the merits of the operation specified in the original application submitted by Nevada Organic Remedies, LLC. The second condition would be, well, I would move for approval that we partially grant the waivers requested with respect to regulation 5.112. And those waivers would be conditioned that they would expire at the consummation of each transaction. And then finally, that the Planet 13 Holdings, Inc. Shall submit a stockholders list on or about their date of record annually to the CCB. And I believe that would do it.
If we have a motion, do we have a second?
Mr. Chair, Jerry Merritt, for the record, I second the motion as stated.
Motion's been properly made and seconded. All in favor, please say aye.
Aye.
Aye. We thank Planet 13 Holding Inc. and M&M and their respective agents for their candor and their help in going forward with this item to state. As I stated, we're on new tenuous ground. We're trying to get it right. We don't want to make it any more difficult than we need to for those in the industry. However, we've been charged with gathering information. This seems to be kind of a moving target. We'll see how it develops. But we thank you for your cooperation and information this day. And that concludes this portion. Mr. Staley, thank you and your fellow agents for the information provided today. We know it was a lot of work. We really appreciate the information provided.
Thank you, sir.
Thank you.
That now takes us to request for final licensure.
Thank you, Chair. Tyler Klimas for the record. We'll now move to consent agenda item D, request for final licensure. Board, before you for approval is the request for final licensure for Circle S Farms LLC RD 374, located at 631 South Las Vegas Boulevard, in Las Vegas, Nevada, and Acres Dispensary LLC D208 RD 208, located at 940 East Altman Street, Ely, Nevada. These licenses have met all regulatory operational requirements following final inspections and staff review. As a result, staff recommends board approval of both licenses to begin operations. Chair, I'll turn the item back to you.
This is a request for licenses. First license that is up is Circle S Farm, and just for generic purposes, located in Henderson, Nevada. We do not seem to have any issues with them unless a board member has any questions they wish to pose to the state. It's on for final licensure. It's on for consent. Do we have a motion or questions?
Chair, just to confirm that Circle S is in Las Vegas, Nevada, just to clarify.
Thank you. Hearing no questions, do we have a motion for approval as to Circle S?
Mr. Chair, Jerry Merritt, for the record, I move for approval of number 1, Circle S Farms LLC, and number 2, Aces Dispensary LLC.
And do we have a second? I will second for approval. We have a motion, we have a second. All in favor of approval as to Circle S, please say aye.
Did
Aye.
we hear the second? Aye.
Aye. Motion's carried.
Sorry about that, Mr. Chairman. I was on mute.
That moves us to item number 2 under D. Acres Dispensary LLC in Ely, Nevada. We have paperwork that's been provided, no areas of concern, all the conditions have been met, and inspections properly done. Do we have a motion for final licensure?
Mr. Chairman, this is Member Nylander. I would make that motion for final licensure.
We have a motion. Do we have a second?
Mr. Chair, Jerry Merritt, for the record, second.
We have a motion. We have a second. All in favor, please say aye.
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 Aye. Motion's been made and carried. They are final approval. That takes us to item number E.
Great Chair, we'll now move to consent agenda item E, consideration of the proposed settlement agreements. Before the board today are two proposed settlement agreements between Natural Medicine LLC and the State of Nevada Department of Taxation and High Sierra Holistics LLC, TRNV P098 LLC, and the State of Nevada Department of Taxation. Both settlements pertain to the case of INRI Department of Taxation litigation case number A19-787004-B, pending in the 8th Judicial District Court. Steve Shavorsky, Chief Litigation Counsel for the Attorney General's Office, is on hand to discuss each agreement and or answer any questions the board may have at the board's request. So I'll now turn this back to you, Mr. Chairman.
Thank you. Chair Douglas, if we have counsel from our AG's office, Steve Szborski, if he can give us an update.
Good morning, Mr. Chairman, distinguished board members. Stephen Szavorsky, Chief Litigation Counsel for the State of Nevada. For the record, it's my privilege to recommend for approval today two settlement agreements that arise out of the ongoing marijuana licensure litigation in the 8th Judicial District, Department 11, before the Honorable Judge Elizabeth Gonzalez. These settlement agreements are what I would characterize as follow-on agreements that were entered into after the partial settlement agreement was approved, conditionally approved by the Nevada Tax Commission and then by the Cannabis Compliance Board thereafter. I'd like to start with the first settlement agreement involving the Natural Medicine and the Department of Taxation. With respect to this settlement agreement, Natural Medicine is contributing towards a payment obligation that is owed under the partial settlement agreement previously approved. And that's a payment of $100,000. That does not go to the DOT, but rather goes towards a payment that is owed by Live Free. With respect to any obligation in exchange, any obligation by the CCB, it's to make a good faith effort to expedite and process a previously submitted transfer of ownership application between Natural Medicine and MediPharm LLC. In exchange, Natural Medicine is agreeing to dismiss with prejudice its complaint in the marijuana licensing obligation. As with the previous settlement agreement that came before this distinguished board, this does not shut the courthouse door on anyone who wishes to vindicate their rights before the Honorable Judge Gonzalez. Everyone to this settlement agreement fully recognizes that the remaining parties to that litigation may prevail, but Natural Medicine and the Department of Taxation believe it is in their best interest to enter into this agreement. Natural Medicine fully recognizes that the CCB is agreeing to expedite and process, but not approve. Any approval would be subject to this board and the state and the laws of the state of Nevada as the CCB interprets them. And with that understanding, I'd recommend approval by this honorable board. With respect to the second agreement that's my privilege to present to the CCB today, this is an agreement where there are, in contrast to the prior one, there are three parties One is High Sierra Holistics, LLC, a Nevada limited liability company. The second party is TRNV P098, LLC. And the third party is the Department of Taxation. High Sierra Holistics is a plaintiff in actually 3 actions against the Department of Taxation. 2 of them are in the United States District Court, Northern Division, and they have been, as I recall, consolidated up there before Judge Hicks. The other action is in state court before the Honorable Judge Gonzalez. And in this agreement, High Sierra Holistics is agreeing to dismiss with prejudice those 3 actions. And in doing so, it is asking for a good faith effort to expedite and process High Sierra Holistics transfer of ownership application. And that ownership application pertains to the purchase of a license from TRNV P098 LLC. That entity is an entity run by a distinguished veteran, Shane Terry, who submitted a letter during public comment in favor of this agreement. This agreement contains a similar term about a 14-month extension that was approved at the prior partial settlement agreement. And the terms are pretty much identical to the partial settlement agreement approved conditionally by the Nevada Tax Commission at the prior hearing, and then approved at the follow-on hearing to the extent permissible by this distinguished board. With that introduction, I recommend heartily both settlement agreements for approval by the Cannabis Compliance Board. I would note for the record that this will also go before the Nevada Tax Commission for approval, that at a publicly noticed meeting, and that is going to occur, as I recall, on the 27th, which is a Thursday. And I believe it's at, I think it's at 11 a.m., but I could be wrong about that. That's publicly noticed by the Nevada Tax Commission for the 27th. And I'm happy to answer any questions if I can.
Questions by Chair Douglas, questions by board members?
No question for me.
No questions for me, Mr. Chairman.
And no questions from me. I would note that the CCB would not be obligated to do any more than they are not
Sir,
already
I
obligated.
I cannot hear you. Please speak into the microphone. Thank you.
This is Chair Douglas. I would note that the Cannabis Compliance Board is not obligated to do any more than they normally would be obligated to do in light of the settlement. The majority of it is between 2 private parties, with just requests that we do certain expedited service if at all possible. But that puts an onus on the licensees to timely get their paperwork into us so we can do our necessary checks before any action is taken. With that, I would make a motion for acceptance and approval of the settlement agreements that are before us as to Nevada Medical and HSH items 1 and 2.
Mr. Chairman, I would second that motion.
We have a motion that's been properly seconded. All in favor, please say aye.
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 Aye. Motion's been made and is carried. Moves us to item number E.
We'll go to agenda item 6, Chair.
Yes.
Agenda item 6. This is the consideration of the dispute over request for change of location between Cheyenne Medical LLC and MediPharm LLC. Chair, members of the board, this item stems from an apparent dispute over a change of location request by 2 licensees, Cheyenne Medical LLC and MediPharm LLC, for the same location. Approved under the Marijuana Enforcement Division, CCB records recognize MediPharm LLC as the licensee conditionally approved to locate to the address of 2975 Sammy Davis Jr. Drive, Las Vegas, Nevada. This change of location was submitted on November 21st, 2019, and approved by the MED on January 10th, 2020. There was no signed lease submitted with MetaPharm's change of location request, as the MED did not require a signed lease as part of a change of location approval. On May 15th, 2020, the CCB received a request from Cheyenne Medical LLC, doing business as Thrive, to relocate from 5130 South Fort Apache Road in Las Vegas, Nevada, to the same address of 2975 Sammy Davis Jr. Drive, Las Vegas, Nevada. The request from Cheyenne Medical LLC contained a signed lease agreement for the Sammy Davis Jr. Drive property. There is currently no licensee residing at 2975 Sammy Davis Jr. Drive, Las Vegas, Nevada. CCB staff is requesting guidance from the board on how to proceed with this matter, including the next steps the board would prefer the CCB take to move towards a resolution on this issue. Chair, I will turn the item back over to you for any questions and discussion. I have CCB Counsel Senior Deputy Attorney General Ashley Balducci here to assist in answering any questions. So Chair, I'll turn this item back over to you.
Can we have counsel, Chair Douglas, if we can have counsel come forward? Is there information that would be helpful, or from your standpoint, helpful for the board to consider when this item comes back before us in September, so that we would have everything in front of us prior to the meeting and allowing the individuals to make representations at that time
Sorry, go ahead, finish.
to try to resolve this issue?
Good morning, Chair. For the record, Ashley Balducci, Senior Deputy Attorney General. Good morning, board members Merritt and Nylander. You're correct, Chair. I don't believe that's a bad idea to get more factual information. I did do my best to try and get the legal positions of the two licensees. However, as far as my own independent investigation, I'm not entirely sure if either of these licensees were the original or the extended applicant for the special use permit. So I'd like to see more information on that, who requested the extension of the special use permit. As far as I can tell, it was a different licensee. But again, I'd like to be able to get those facts from the two licensees in order to vet out the issues.
Chair Douglas, for the record, yeah, it seems to be a convoluted process at this point. We have someone who appeared, originally made a request for a special use permit, which was granted under 453D 210-5C3 originally, which is now expired this month, but it would be grandfathered in for that particular purpose. There's a question of whether or not that condition applies to anyone else, but that would be the status with the county. But there's been a question brought as to propriety of the first party having a right to be on the property, or whether that right to be on the property has in fact ended, which would in essence end that licensure's right to still be there. And then we have the secondary party who says they have a signed lease to be on the property. So there are more questions than answered at this point that need to be laid out. I, for one, would like to see both parties present to us within 10 days starting from tomorrow their position as to why they should have a license, or in fact have a license and be able to retain that license, from the zoning to the propriety of being properly on the property. Thereafter, and these are blind to the board, 5 days each to respond to whatever's been written by the opposing side. And they will be allowed to make a limited presentation to us in September. That would be my request. If there's something else that board members would also like, please so state, so we can get everything thrown in the basket that needs to be thrown in the basket to hopefully allow clarity of this issue.
Mr. Chairman,
Chair,
this is Board.
Go ahead, Board Member Nylander. I apologize.
Well, I was just going to, in response to your request, just to add a few things in particular. And I'm sort of looking at this from the lens of a gaming grandfather, which has gone in existence with respect to resort hotels back to 1991. And it has its own challenges as well, but at least in that particular statutory scheme, the grandfather clearly runs with the land. But there's also a provision with respect to gaming that the grandfather can't go dark for more than 2 years, or else the right is lost. And I'm just hoping Ms. Balducci can sort of look into, and I know the law is not specific, unfortunately, especially based on what I've read from both parties so far. There's actually nothing clear. It's clear as mud. But to the extent that you could look into, is there some way that under local law, which I'm not familiar with, but I know there's an SUP on this thing. When does the SUP expires? Who has the SUP? Does the SUP extend the grandfather to another party, even though there's not a lease? So that's the kind of thing I was, just to follow up on what you've already asked for, Mr. Chairman.
Member Nylander? Excuse me, Merritt? That is the kind of information the board will request. I would ask council to just provide a notice to the two parties requesting that information be provided. And they're blind. They don't need to see the other sides initially to write their first salvo to us as to why, and then they can respond given 5 days thereafter, after the 10 days, start from tomorrow, as to why they would reassert their position or find fallacy with the other side. This is a novel question for us. We hope to get it right, so we're wish to get as much information as we can. And again, it's not on for action today, except to make a request for information. September, we would allow them to make a limited presentation to us as to the respective position, highlight whatever they've provided us in the written material. That would end this item, unless you have something else.
I do not. Thank you, Chair. Thank you, Board Member Merritt and Nylander.
Thank you. That moves us to our next item, number 7, our next meeting date, which is September 22nd, 2020, unless something would come up that would change that particular date. And any board member have an item number 8 for future agenda that they would request?
I have none, Mr. Chairman.
Please.
I have none.
All right. That would then take us to additional public comment if we have any, and whether or not we need to take a break before that's done, or whether we're able to go forward with that item.
Thank you, Chair. Tyler Klimas. For the record, we received no additional public comment, so we are okay to move on.
That brings us to my favorite part of the agenda, adjournment. Do we have a motion for adjournment?
Mr. Chairman, I would second that, Mr. Chairman.
It's been moved in second. We are adjourned. Thank you very much.
Thank you.